you who are tuning in live are here with us, we're super excited that people are also watching the recordings too. So both of those are a good option. Like Nathan was saying, we plan for about an hour and a half, but our content is about an hour, and then we'll take questions. If we have time, we can answer them right away. If we need to do some research and get back to you, we'll do that. Either way, we are hoping that we can be helpful in your farm transition journey. So today is day 3 of 4 parts of this webinar series. So we'll be together today and then one more time next week on September 4th. So same time, same day, and you'll get email reminders about that. So if you remember, last week we talked a little bit about that business succession, but then we also got into fair versus equal. We started talking a little bit about property transfer and how to do that, the different ways. So we're going to kind of continue on with that today. So we're going to be talking about transfer of assets today. And last week, Nathan talked a little bit about selling your assets, which is one of the options. We're going to get into a couple of more strategies today. But I just want to remind you, we are the Agricultural Business Management team at University of Minnesota Extension. I'm Suzanne Henricks. I'm an extension educator with the team. Nathan Holinsky, who's been talking, he's also an extension educator. He'll be teaching a little bit later on in the session. And then we have Dave Bow, who's been on the team for a long time. He really knows the stuff, and we appreciate him being here as well. If you want, you can take down that website that we have on the screen here. That is our link to the Farm Transition website, where we share a lot of resources on the website that you can review, and it's in written form. So that's always a great resource for people too. So remember that our webinar series is really to help you be able to share your goals and how you want your farm transition to happen with others. Maybe it's the family members that you're going to be working with on a transition. Maybe it is employees that you're going to be transitioning it to. Whoever is going to be involved in that transition, and also those are important people to communicate with, but also people who are in your family that aren't involved day to day, they also, like we talked about last time, need to have a certain level of information as well. So reminder that we're all at a different place. All of our farms are different. Even if you are a neighboring farm next door to another farm, your ancestors, how you farm, that is special to your farm. That's how you've kept viable and you're successful on your farm. That's just special to your farm, and those are important things that you keep going on your farm. Also, we're all in a different spot in our farm transition journey. You might be just tuning into this series for the first time, or maybe you've watched it before, and maybe you're farther on down in your transition journey. So know that we're giving you ideas to help, and we're educators helping to bring thoughts and help you think about your transition as you plan it out. So last time, Nathan started talking about one of the ways that you can transfer your assets, which is sales. So he talked about the top bullet here, and sales are, just as a reminder, they happen while you're alive. You could sell a tractor, you could sell a piece of equipment, you could sell a piece of land to another person. Remember that there's no step up in basis. It's just that sales price becomes the basis for the new owner. So that's what Nathan talked a little bit about last time. If you weren't able to join us last time, that video is up on YouTube on the Agricultural Business Management page. And Nathan is he said he would put that link in the chat. So at some point you'll have it again. We did put it in the chat before 10 o'clock, but for those of you who joined after that, we'll put it in there again. Today, we're going to talk about the other 2 ways that you can transfer assets. That would be gifting, and that would be inheritance. And inheritance, Nathan's going to talk about that. He's going to talk about wills and trusts. And that is, wills are the most common way to transfer assets. So we're going to talk a little bit about that, but Nathan's going to get to that after a little while. So remember, a lot of this has to involve basis. And so this slide is in here just to remind us of how basis is affected in each of the ways that we transition. Like we just said, sales, when you sell an asset to someone else, the basis doesn't get stepped up. It's not kept. It's the new price, the price that you had as a sales price, that is the new person's basis. So that's kind of an easy way to think about that. And we're going to talk about basis for gifts and basis for inheritance too. So as a reminder, these are the three ways. This slide kind of transitions us into what we're going to talk about today. Gifts, and then using an inheritance mechanism. All of these are choices, and you could do a mix of these things if you wanted to, but all of these are choices and they have a possible effect on basis. So I'll kind of get into gifting now as we think about gifting assets. So what is a gift? A gift is something that you give to someone else. That's how you can transfer assets. That's one way to transfer assets. You can start as an entering generation. Maybe you as the ownership generation want to help the next generation get into the farm business. You can gift things, equipment or land, a percentage of the business to another person. So we're going to talk a little bit about that. You can transfer income to children that might be in a higher tax. You might be in a higher tax bracket, and maybe your children are in a lower tax bracket. That's a nice thing to be able to do to reduce your taxable estate. There are other ways and reasons that you would do a gift, and that might be for a charity as well. So you can give to your church or to a charity that you're fond of, and those are possibilities as well. So you can give gifts to a charity now while you're alive, or you can arrange for it for after your death as well. So gifting assets. Let's talk a little bit more about gifting assets. In many cases, gifts do not result in being a taxable event for the donor or the recipient. So that's something to remember. Gifts really aren't a taxable event. Every person in the United States, this is a federal amount. As of 2024, you can give someone else up to $18,000 worth of assets. It could be land, it could be equipment, it could be money. You can give up to $18,000 worth of assets to another person without incurring any tax. So that's an annual exemption that we have. You can do that as much as you want, and that is per person. So if you're married and you both are involved in your farm, you each can give $18,000 to someone else. So let me give you an example. If you farm with your daughter and your son-in-law, you are married, you have a spouse, you as an individual can give up to $18,000 to your daughter, and you can give up to $18,000 worth of assets to your son. Then your spouse can also do that too. They need to be separate transactions, but you can do that as yourself as an individual, and then your spouse can do that too. So keep that in mind. I mean, it could be that you've been paying your son, your daughter and son-in-law a wage for working on the farm, but you wouldn't be where you are today without their assistance, their help, and you want to start giving them a little bit more ownership in the farm. This is a way to do it, gifting some of your assets to them. So that $18,000 maximum for your exclusion is for this year. That's a 2024 amount. Last year, as the slide says, it was $17,000. It does get adjusted for inflation. So that's something to keep in mind. And that's an annual exclusion that we all get. We can all give assets to someone else as you want each year. On top of that annual exclusion, there is a lifetime combined exclusion. Now, this adjusts for inflation as well, but right now for 2024, it's 13 million. And that's something to consider. And that's your lifetime exclusion. So you need to be able to keep that in mind when you're thinking about your gifts. So let's say you give your daughter or your son some assets and they total more than the $18,000, then that difference is not included in the exclusion, and it chips away at that 13.1 million in your lifetime that you can give someone else. So keep that in mind. You would need to file, a gift tax return for that amount. And you also want to always make sure that you're keeping good records of any assets that you're giving to someone else, because it's just really good business to keep track of all of that in your record keeping. Let's see, is there anything else I want to cover on that? Yeah, the tax law changes. So there was a tax law that changed in 2017 that made the exclusions go quite high for a lifetime of gifting. So this is something that you'll want to just keep tapped into. It's set to sunset at the end of 2025, and hopefully we hear, from the IRS over time of what that might be changing to. So this does sunset the lifetime per person gifting sunsets at the end of 2025, and there will be a new amount announced at some point. Now, for Minnesota, there's also Minnesota, and then we're going to talk about that too. So you need to keep track of federal and Minnesota. So gifts, you need to value them at the fair market value. So if you think about basis, a gifting, this is where you need to think about if you're giving land or if you're giving something that could appreciate, the basis goes with the gift. So when the donor would have obtained that asset, their basis travels with the gift. And so the gift, the basis is the new owner's basis. So that's something to consider. And we're going to talk a little bit about that in a little bit. I have a story for you that will help illustrate what that means. So if the recipient were to sell the gift in the future, likely that would cause a greater tax burden on the recipient because of that low basis that came from the donor. So that's something to think about for land or for whatever type of thing that could appreciate. Then when utilizing partnerships or a corporation, you can actually gift a little bit more because of discounting. And I'll tell you about that in a little bit too. So discounting is allowed by the IRS, and it's something that's totally legal in the eyes of the IRS. We need to be careful about it, but it is allowable. So about discounting. If you look at the two pictures here on the screen, one is of a family taking a stroll through a park, and then the other is of a crowd. So I'll explain discounting using these two pictures. So the IRS says that if a farm, it's closely held, mostly by family members, closely held people that are working together to keep that farm going and being successful, the IRS says it is allowable to discount assets, because if comparison to the crowd, you might have a publicly traded company where anyone is able to kind of determine what the shares are by the beginning and the ending trade day, and then you take the average, and then there you go. That's your value of that company. Anyone can buy into that company, and anyone can be a part of it. So discounting isn't a part of that larger publicly traded business corporation. But discounting is allowed at a farm because it's closer held. You're not going to be out on the street looking for buyers to buy into the or I should say gifting into that business. So that's why the IRS allows that. We usually say about a 15% discount, up to 40% is allowable. That's what the IRS says. But remember, make sure that you have your comfort level of when you are looking at that discount gift that you're giving to someone else. Maybe it's a share of your farm's company. Then keep that in mind, that the higher the discount, it could, trigger an audit if it's too high and it just seems like it's, egregious. So make sure that you have a stomach for it and that you think about what amount you're going to discount that. So that is something that you can do, and you can gift annually to someone to give them a share of your business annually. So that would be something to do if you wanted to kind of reward someone who's been working with you for a long time and you want to gift a certain percentage of the farm each year, you could do that. So that's discounting, discounting gifts. So I have a story for you on the basis story. So remember I said that if you are gifting something to someone, then your basis, the donor's basis, goes to the recipient. So a colleague of ours had received a phone call a few years ago from someone who wanted to know about basis and gifting. And ultimately, the question was, he explained that he was in ill health. He wanted to gift because he didn't want the step up in basis. So if you remember last week, Nathan talked about selling assets. And if you sell it, you get that stepped up. You don't get a stepped up in basis, but you get the new sales price. That is the new person who bought it, their basis. Nathan's going to explain that as you transition an asset through, let's say, a will, that will get a stepped up basis upon the person who owned it, upon their death, for the person who is inheriting that. But in the case of a gift, that isn't the same. The basis goes with the donor to the recipient, and the donor's basis is the recipient's basis. So this gentleman wanted to gift land to his family members because he really wanted to make sure that that land stayed in their family. He didn't want that stepped up in basis. So he was really asking about gifting his land before his death so that he could assure that the capital gains would be so much that they would really have to think twice before gifting or before selling the land. So that's something that just illustrates the gifting versus the other ways that you can transfer an asset. So keep in mind that when you are doing gifts, I mentioned it a little bit earlier, but I really want to stress it, that try to keep good records of any gifting that you do give. This is good practice just for your own record keeping, also for the recipient's record keeping. If you can, notarize things, because that also shows that you have taken that extra step and it's official in front of a notary public. List the date of the gift, list who it's coming from, who it's going to, the fair market value. So we haven't talked much about how do you assess the fair market value of a gift. Well, if it's something that it's questionable, or you really want to know what the fair market value would be, an appraisal would be a really great way to get that fair market value. So there are many ways you can kind of try to find out the fair market value of a gift, but that's an important thing, just to note what the fair market value is. Remember, the basis goes from the donor to the recipient, and that's their new basis. But still, it's nice to have in your record keeping, because you'll need to know if it was over 18,000 or not. And then list things about the assets, such as the make, model, and serial number, and then describe it. So it's good to have that in a document that you keep in your records, whether it's electronic or in a file in your hanging file cabinet. Either way is fine. And then store the document in a safe place and just make sure that everyone knows that it's there. This is a good idea, not only for the donor and the recipient, but it's a really good idea when you are explaining this to non-farm heirs. It's really good so that if you're looking back, you can say, yes, we did give that tractor to our daughter, or yes, we did give that parcel of land to our son so that others can see the document. So that's an important piece of this too. So what about taxes in all of this? So let's dive into that a little bit. So if you give a gift to a person that exceeds that $18,000, which is your annual gift exclusion, then it kind of, like I said before, chips away at your lifetime exclusion. Okay. You do need to file a gift tax return, and that's file number 709 that's listed on that second bullet. So just know that you don't have to pay any tax right then, but you do have to note it because it is a part of your lifetime exclusion. And remember the last bullet there, this could get wrapped up in your estate. If someone gives a gift in the last 3 years of their life, that's something to keep in mind, especially that last year, that you want to make sure that things are recorded. But if the donor dies within that same year, it could get wrapped up in the estate. So that's something to kind of keep in mind. So a recap, exceptions would be typically a gift does not result in the tax to the donor or the recipient at the time of the gift. There are exceptions, but typically that gift does not result in any taxable implications. It could have financial consequences. If you think about, let's say the ownership generation gives away a lot of their assets, and then later on in life, they needed some of those assets to pay for their care or something like that. So that is something to think about. Can I afford to give away some of these assets at this time? And then how do gifts fit into your broader farm transfer and your business succession goals? I mean, there are reasons why you'd want to gift something to someone. Maybe it is giving them a little bit of ownership in your farm as time goes each year. There's lots of reasons why you'd want to, and then reasons that you maybe don't or you can't do gifting. So these are some of the topics that gifting can give you a leg up, or it can be a way to help with your farm transition goals. So what if ownership transfer isn't desired at this time? So what if selling assets or gifting assets isn't really desired at this time in your farm transition plan? I mean, think about other options. You can do leasing. I mean, it's very common for an older generation to lease land to a younger generation, and farming happens that way. It can even be that way for someone outside of the family. You lease your land to someone and help them get started. If you want to, you can think about typically machinery only tax. So if you're leasing a piece of machinery, that would be subject typically to a self-employment tax. So we suggest, as the third bullet kind of states, you maybe want to combine your leases. If you're leasing land, you could wrap in a machinery lease, and then that would avoid the self-employment tax. So think about when you're leasing, how and what you're leasing to another person. So remember, gifts, there's no step up in basis. Gifts, that basis transfers with the donor, and that's the recipient's basis. So these are the ways that you can transfer things, assets. So wills, trust, that's what Nathan's going to talk a little bit about. So I'm going to talk about a couple more things before I turn it over to him. And one of them is this fair market value under the current law that's allowable. So let's talk a little bit about special use valuation. So an alternate way to value farmland, the special use valuation is an alternate way to value farmland to reduce estate taxes. So this is another option for you to consider. And there's data out there that is used for this special use valuation. So this allows for the reduction in the value of your land from the fair market value to a value for estate tax purposes. And it's really about farm production values instead. So it's called special use valuation, and you would need to work with a professional in getting this set up. But this is something that is an option for you as you think about how your farm transition and your plans and goals are. So the IRS calculates for farmland the special use valuation based on the things that are listed here on the screen. Land rent values, it's a 5-year average that kind of goes into the calculations. Real estate taxes on the property, and then data from Agribank, and then that's regional interest rates basically. And then also a 5-year average of interest rates. So keep that in mind as an option. This is called the special use valuation, and it's based on the farm production value instead of real estate values. That's a fair market value differentiation. So that's something that you could look into if you wanted to reduce the value of your land that's transferred through an inheritance. So that's something for you to consider. And this is really used when you want to avoid federal estate tax. It's very technical, and we want to make sure that you have a way to work with a professional on this. An attorney would be a good option that knows about estate planning, maybe an accountant, but most likely an attorney that's doing estate planning. Okay, so then federal estate tax. I want to just hit on the federal estate tax, and also there's Minnesota too. So I'm going to talk about two different things, both the federal level and the state level. So federal estate taxes are assessed only on the amount that exceeds that annual exclusion or your lifetime exclusion. So you know that the lifetime exclusion is 13.61 million. That's for 2024. That will be adjusted for inflation as over the years. And that amount is expected to sunset with the current tax law as of 2025. So that amount it will change. We don't know what it's going to change to yet, but it will change. So that's your federal estate tax. Remember, for federal, you have an annual exclusion of $18,000 per person to be able to gift someone else. Oh, no, I'm sorry. I'm not talking about gifting. I'm talking about estate tax. So right now, your exclusion is 13.61 million for 2024. So that's your federal estate tax. All right, so let's go on to exclusions are and a credit are per person. So this is really important that it's not per couple, it's not per farm. For your federal estate tax exclusion, that's per person. And exclusion means that you can exclude that amount from your taxes. So yes, it is about that per person annual amount of 18,000, and then it is that lifetime amount of 13.61 million right now under 2024 law. And remember, anything that's unused can be portable to the spouse upon one of the spouse's death. So that's something that's important too, that it's portable and that you can use your spouse's exclusion upon death. So something to keep in mind, that tax law does change right now. 13.61 is quite a high number if you are looking at gifting or your estate and your planning. So I have a poll for you. For those of you who want to, in the Q&A box, you can answer this question, okay? So Minnesota has a lower estate tax exclusion than the federal government. So remember, the exclusion is the amount that you don't pay in taxes. You don't pay taxes on. So that's the exclusion. Does Minnesota have a lower estate tax exclusion, or does the federal government? So I'm seeing some people answering true, and Minnesota has a lower Yes, exactly. Minnesota has a lower estate tax exclusion. So you guys are paying attention and you know your stuff. Thank you. So this is kind of a segue into, all right, we have federal, and we also want to make sure that we remember we are in Minnesota. And so we have to pay attention to Minnesota estate law, tax law too. So Minnesota has its own estate tax. The impact can vary depending on the value of your assets, things like that. So even though there is no federal estate tax owed, a Minnesota estate tax could be owed. Now let me explain that a little bit. So the Minnesota estate tax currently is between 13 to 16%. So remember, the federal level is, I haven't mentioned it yet, but it's about a 40% over that 13.61 million. So for an estate tax in Minnesota, the tax rate is 13 to about 16% currently. So Minnesota has a personal property estate tax exclusion. I'm sorry, estate exclusion of 3 million as of this year. That always changes for inflation, and it could change for inflation. So using the personal exclusion and the qualified property exclusion, an individual could have 5 million. So let me explain that a little bit. So if you have the 3 million, Minnesota allows you Minnesota estate tax. This is in addition to the federal state tax. So I think I'm going to have Nathan kind of explain that when he gets on a little bit more, because I didn't explain it very well. But I want you to remember federal and a Minnesota estate tax, they both are per person. They're not per couple or per farm. So anything that you do regarding your estate is per person, not per farm or per couple. So something that that is available, there's an additional estate tax exemption for qualified farm property in Minnesota. So this is something that if you were to look this up, it's called qualified farm property, and it's an additional estate tax exemption in Minnesota. There's something similar to for businesses, for business owners. So this is something that Minnesota does. So in addition to the 3 million that Minnesota has for the exclusion of estate tax, in the taxable year of death, property that is classified as agriculture, so that's 2A, with agriculture homestead, so it needs to be that the person who owns it has lived on that property in the past and currently does or did before their death. And then that the people who are going to be receiving the land are family members, and that they're going to be farming it continuous ongoing. That's a part of this Minnesota qualified farm property exclusion. So if you have that situation, this is something to research and to look into. So remember, it needed to be owned by the decedent or family members for 3 years before that person's death. And it must be passing to a qualified family member. And a qualified family member would be a spouse, a child, grandchildren, siblings, a parent. So if that situation fits, this is something to check into. And it used to be tax law changes. It used to be that that farmland and the homestead needed to be maintained by the next generation. That's not written into the current Minnesota tax law. So it just needs to be, the land needs to be utilized and maintained as farmland ongoing. So that's the additional estate tax exemption for qualified farm property in Minnesota. So this slide pretty much explains that the decedent had lived and it was owned by the family for 3 years before their death, and that qualified heirs are the recipient through like a will, that they will be farming and maintaining that property as a 2A agricultural property. So it has to be for 3 years after. So this is something to look into if you are interested. Also, I should say, so I didn't say it specifically, but I want to say it, that if the family after a decedent has passed away, if they were to sell that land for development, that does not work. You have to have the land being producing and farming and being an agricultural designation. So what about if, you know, this is an additional estate tax exclusion for qualified farm property in Minnesota. It's very specific. So the qualified farm property exclusion, it's very specific. It lays out exactly what you have to have. If for some reason you don't follow the rules, you could be on the hook for a recapture tax. So keep that in mind and try to know and get to know an attorney who can help you transition this and be a part of your estate planning, and make sure that the person who's working on the estate knows about the rules within a lot of these things. But recapture tax is 16%, and it could be triggered if the heir sells that property or doesn't maintain it as an agricultural classification. So you also have to properly file tax returns after that as well. So those are my slides that I am covering. I talked a little bit about gifting, and that's a mechanism for the transfer of assets to a next generation or to a next operator. Last week, Nathan talked a little bit about sales and how that could be used as a part of your transition plan. Now, Nathan's going to follow up with anything that I didn't explain well enough, or if there were any questions in the chat. But then also he's going to take us through transfer through a will and also trusts. So Nathan, I'll take down my slides and you can upload yours. I'll take a look at the chat questions too of the Q&A and see if there's anything in there for me.
Are we seeing my screen?
Yes.
Okay. All right. Well, before we get started, I think there's one in the chat. I think Dave Bow is answering that, so I will keep going through with the slides that we have. So just to reiterate, on the federal side, again, each individual person has $13.61 million of federal estate tax exclusion. So pretty large number. So if you have a couple that owns the farm together, husband and wife, we're talking some $27 million. So pretty big number. Again, on the state side, it's $3 million per person, plus that $2 million in small business or farmland exclusion, up to $5 million a person. Okay, so again, that's a big number, like our screen says, but we do want to highlight that as of currently, the federal limit of 13.61, that will decrease January 1st of 2026. So that 13.61 is the 24 number. The 25 number will be adjusted for inflation. So add, you know, roughly, I don't know, $250,000 to that. So be close to 14 million per person. And then in 2026, that will return to 5 million plus inflation. So somewhere between $7-8 million per person. So we'll decrease close to $5-6 million per person on the federal side if nothing changes. As most of us are aware, there is a presidential election in about 2 months, and this is some of the talking points that both sides are discussing of changing this. So just keep that in mind, and when you go to vote, keep this in mind. So what happens if you're over that, right? So the maximum estate tax rate on the federal side is about 40%. So again, if you're over that 13.61 million per person, it's going to be about a 40% tax rate. And then on the Minnesota side, we don't have a gift tax, but you add back 3 years of gifts to your estate. And then and again, you have that up to 5 million per person. That's that 13 to 16% tax rate. And again, we just want to highlight this is as of today. These can change in the near future or the far future. As of today, these are accurate. So moving on here, so what's included when calculating your estate, right? So both probate property and non-probate property. We'll kind of highlight that a little bit here. Again, if they have what percent of land that they own in joint tenancy property. We discussed those property classifications last week. Also, the decedent share in a sole proprietor, the share of tenancy and common, community property assets, the percent of pretty much all property that they own is going to be included. And we can see properly owned life insurance are not included. And I'm not a life insurance expert, but we just want to make sure that the beneficiaries are listed properly. And if it is properly, it will not be included with their gross estate. But if it's not quite filled out correctly, it can be. So just be aware of that. And then allowable deductions, so the funeral expenses, if there's some last medical expenses related to death, administrative and legal fees, all debts that individual had, claims that are paid, given to charity, generally that's allowable, and then some to the spouse as well. So those can be deductions from the estate. So that's how you calculate what is your gross estate value. And next we'll be talking about a will. I think everybody has heard of what a will is and has a general idea of it, but it is an important document. It's a legal document that's going to name your personal representative. So that personal representative is going to help fill out your will's wishes after you pass on. So the will also include instructions for the distribution of your assets. So this is a court supervised process. And also the will list the names of the guardians for minor children. So if you have kids under 18, what would happen with those children if both mom and dad pass on? And then also the name of the conservators of your minor children. So that's going to be more the financial decisions versus the guardians are going to be the physical care and actually helping them grow up physically. And then the conservator can be a separate person, is more on the financial side. So although with this will, it's an instrument that carries out the wishes for your estate. So the assets, the stuff you own, the children that you are responsible for, it will list that out. You can leave property to someone who would not inherit under the state's intestacy laws. So what happens if you die without a will? The courts get to decide what happens. And typically, the court will say, hey, you have a wife, they get, I'll just say, they'll determine the share if it's 50%. And then if you have 4 children, each of your 4 children will get that remaining 50% split 4 ways. So each of your children will get 1/8 of what your estate is worth, and your spouse will get the other half. That's, it'll change per family. But if you die without a will, the courts will decide this. And if we remember, we're pushing 10 years ago, but Prince, right, the Minnesota musician, passed on without a will, and the courts were deciding that for years on who got Prince's assets, right? He was worth roughly $200 million, and all of his cousins and half siblings and potential children were trying to get a piece of that. And it took a lot of time, a lot of dollars, and really the only winners in that fight are the lawyers, right? The lawyers charge their fees and they get to deduct that out of the estate for their transaction fees. So having a will is important. And again, with the will, you can prevent a person who would inherit under the state's intestacy laws from inheriting. So maybe you have a child that you are having some difficulties with in their adult years, and you don't want them to get a quarter of your estate. You can write that up in your will that crazy son Nathan, he gets, he gets $500, where in the court's decision, it would maybe be 10 times that amount. Also, you can leave property to heirs in unequal shares. Again, the court will make everything equal on the generational levels, to being it grandkids, children, or spouses. The courts are not going to divvy up that your favorite son deserves more money than, your crazy son Nathan, or whatever that's going to be. You can also bequest assets to charities or to under other individuals. So maybe your one best friend that was always by your side, you want to leave them X amount of your estate. You can do that with a will. A court without a will is not going to care about unrelated parties or unrelated people that are nice to you in your life. So just we want to do a polling pause. Do you have an up-to-date will or trust? And I just want to leave this up for 30 seconds for people to think on. Is their will up to date? We don't have the statistics in this slide, but there is a lot of people who die in the United States without a will. And a will can be a pretty simple document. We have a lot of Q&As coming in. It looks like a lot of sort ofs, yes and no's on our poll here on if they're doing them. So again, just keep this in mind. I mean, we have a lot of sort ofs, which probably means they started it, but probably haven't updated it in a while, right? So if you are, listening on and answering this question, maybe it's a good reminder to start creating a will. We have a question here about if you need to do it with an attorney. You do not. You can simply write up a will with pen and paper and sign it and date it. You can have it notarized by, the local post office or courthouse. It's not a bad idea to have a lawyer have a copy of it and make sure it's filed properly, but it is not required to have filed with a lawyer. I know that I have had individuals tell me that they just write it down with a piece of paper, and the judge will typically take that into account when he goes to, read through the probate process. And if there is a written, dated, notarized will that is not with a lawyer, that's typically taken into account. Again, if it's filed through a lawyer, it might have a little bit more regard to it just in that way, but it is not required. Again, you can simply go home and write it down with pen and paper, and it can be a very good starting point. And you can always go back and talk with a lawyer, a little bit later on. So here's another question. Can you disinherit a spouse in Minnesota? Yes or no? Can you disinherit an adult child? Yes or no? So again, answer one, you can disinherit both, or you can disinherit a spouse but not children, or children but not the spouse. So if people want to try to answer that, they've been pretty good about answering some of our other questions. I'll see if some of these come in. We have some answers saying that you can disinherit both. I will answer this quickly, that the correct answer in Minnesota is, there's a few more questions that come in. Some people got that correct in the chat there. You can disinherit adult children, but you cannot disinherit your spouse. In Minnesota, they have determined if you are getting along well enough to still be legally married, you cannot disinherit them. And again, through a will, you can say, you know what, I've still married to my crazy wife. We don't really live together. We're estranged. We're still legally married. You cannot leave her nothing. You have to leave her something. And again, if you are still legally married, that is something that that spouse can argue with the courts and contest the will down the road. So keep that in mind. You cannot disinherit a spouse. As long as you are legally married, the court in Minnesota say they probably deserve something. So functions that a will cannot do, and we talked about a lot of this last week, is that you cannot distribute non-probate assets, the joint tenancy ownership, the transfer on death, the payable on death, or the transfer on death deed. Those are outside of a will. So we talked about some of those are pretty good tools. A will cannot override that. And again, we want to reiterate probate. A will triggers probate. It does not avoid probate. So if probate is something that you're scared of, and probate is more or less this court process that goes through the estate and determines the proper owner of assets after someone is passed on. That's that probate process, and a will triggers probate. It does not avoid probate. So again, just keep that in mind. And part of that, being a court system in the United States, it's public knowledge. So if that's something you don't want to have happen, we can talk about trust, and we'll get there in a little bit. We also have simple or sweetheart wills that typically they direct everything to the surviving spouse or to children if there's no spouse surviving. All right, it can name a guardian or the conservator for minor children, but those can be pretty simple wills. Like I know when my grandfather passed away 15 years ago, his will said everything goes to grandma. Pretty simple, right? Pretty easy to comprehend, and not a whole lot of difficult decisions are made there. Also, we can have the complex will. They can be utilized to create a trust or a structure of another sort for estate planning purposes. Could be entitled, AB trust will or contingent trust will. And here's a quick example that I hope makes some sense. So if we start at the top, again, this is more of a complex will, and this will incorporate a trust into that. So we have husband and wife at the top, each own 50%. When the husband dies, his income will go over to the wife. Okay, I just want to highlight this, and then we can set up this trust through when the husband dies and the wife is in charge of that trust. And again, with a will, probate will be triggered at the death of the wife, the second spouse there. Spouse has the exemption that's also subject to probate. All the assets will then go, the trust assets go to the children at the second death. So it's kind of protected through this trust with the husband that the wife's in charge of, and at the death of that second spouse, then the children kind of take over ownership. So you can set up the will to put them into a trust to protect assets, and then the children can then gain ownership down the road. So there's a lot of different ways to do this, but we will explain trusts just in about 5 minutes in a little more detail. But that's one way that you can move some assets around. Again, challenges with the will. It's a public letter to a judge. Again, probate will occur when the property is over $75,000 or any real estate deed will trigger probate through a will, and any total assets over $75,000, which is a relatively small dollar amount when people are, trying to save up for retirement and have some left over. So upon the first spouse's death, if property is owned individually or as tenants in common, and then the second spouse's death for joint tenancy. And again, unless they're placed into a trust. But again, that joint tenancy, the ownership automatically goes to the other joint tenant or the spouse, however that's set up. Okay. And again, a few more challenges. Requires multiple probates if property in more than one state. So if you have land in South Dakota and Minnesota, you'll have two separate probates. The simple will does not protect assets from lawsuits or other adverse actions, like an heir contesting the will. So maybe your estranged son now comes back and says he was your favorite person and he deserves half of your estate, right? That is the contesting of a will. The simple will doesn't do much to protect against that. Does not include rules for your care if you become disabled or incapacitated. So we'll talk a little bit more about these kind of disablements next week when we talk about some of the more kind of retirement planning and some of the healthcare guidelines. We'll highlight that third bullet point more so. And again, probate time can kind of be all over the place. If it's a relatively small or simple estate, it can be less than a year, but typically it's about a year to a year and a half. The cost can vary, but it'll be roughly 2 to 3% of estate value. I know we've had people tell us in the last year or so that it's actually less than that, where it was only about 1% of the estate value. A lot of this depends on how complicated everything is. If everything is very straightforward, it'll be quicker and cheaper. If there's a lot of distribution of assets or breaking up of different properties, it's going to be a little bit more slow, a little bit more complicated, and probably slightly higher on that cost. Again, the probate of a will is open to the public. The letter to Director of Minnesota Department of Human Services. So I'll spend about the next 10 minutes discussing a trust. So it's slightly different than a will. So again, a trust, it's a means of holding and managing assets. Trusts typically have 4 parts. The trustee, usually yourself as the grantor of the trust. Property, so you need to fund the trust. So that's going to be cash or personal property or land. If you look in a plat book for land ownership in your county and township, it may say Helinski Farm Trust that owns that farmland, or it'll just say Helinski Trust owns land, right? That means that that land has been placed into a trust and it's not individually owned. So that means that that the trust has been funded. Beneficiaries can include, usually yourself, can also include other people, however you set that up. There's a lot of different ways to set up a trust. We're not going to go into great detail right now, but some broad ideas on how the trust works. And then also within the trust, you will include instructions and guidelines on governing this trust and the assets placed into there. And you establish this while you are alive. So that's the big difference between a trust and a will. A will, no one really reads it in the public until after you pass. The trust, you set up when you are alive. Again, it can potentially reduce estate costs. Again, if assets are placed into a trust, they are not subject to probate. So if you are, trust is a private document. This isn't released through the court system after you pass on. It remains a private document. And it can be designed in many ways. The 2 big ones are revocable, which they're changeable, or irrevocable, which is non-changeable. It's the 2 biggest buckets of trust, but there's still within those 2 buckets multiple ways on setting them up. And again, we'll do some brief overview. So starting with the revocable living trust, these are probably more common in the last few years. They're changeable. The grantor places assets into the trust. The grantor typically names themselves as the trustee and the beneficiary. They have the control. They control what happens with the trust and the assets in that trust. There's no income tax consequences when placing assets into a trust. exemption, some of those pre-tax retirement accounts. And setting up a trust, you will have to work with a lawyer of some sort. You can't set up a trust 100% on your own, or I would recommend not doing so, but working with a lawyer who has some trust experience, and they can answer your very specific questions on if this, then what. Moving on here. So assets are included in your estate and are stepped up. They get the stepped up basis upon your death with a revocable living trust. You can add, remove, sell, gift, trade, etc., all with the revocable living trust. Very flexible. It also enables some disability planning by allowing some instructions for your future care. We highlighted just a few minutes ago with the will, this is not an option, right? With the will, you can't really talk about your disability planning. The trust, a lot more leeway in doing so. Okay, with a revocable living trust, a pour over will ensures that all assets, old and newly acquired, can be included into your trust. So you can say, you can have a will that says, hey, upon my death, I want to throw in, the truck that I bought 2 years ago, whatever else into the trust, so that assets in the pour over will are subject to probate, and then the trust assets are subject to estate tax. So again, this pour over will is still a will. It will go through probate, but then they can pass into the trust. And again, at the bottom here, trusts must be funded. If you don't fund the trust, it's just an expensive stack of paperwork of setting up a will or extending up the trust. And again, the dollar amount to set up the trust can vary a lot depending on how complicated it is. If it's relatively straightforward, it could be a couple $1,000s. If it's complicated, it might be several, up to $10,000, $12,000, depending on the lawyers you're working with, and again, how complicated this is. And then you need to fund it. So what does that mean? Sally Jones checking account. That's not funded. That's just a personal checking account like I have set up. Whereas you can have Sally Jones Living Trust checking account. That means that the money in that checking account are in the trust. So again, you do need to go to your bank or your other institutions where your assets are located and put them into the trust. Again, advantages. The revocable living trust will bypass probate, right? They will not go through the estate court. They're very flexible, and you can change your mind up as you go along, right? You have choices while continuing ownership of the assets, allows for the disability planning, and allows you to leave your loved ones an inheritance protected from the divorce, the liens, the lawsuits, etc., while still maintaining control of assets during life. And these last 3 bullet points, or this whole page here, are some of the big reasons why these revocable living trusts are becoming quite popular. They're very common. They have a lot of benefits. Again, some of the challenges at the same time here. Cost of establishing the trust is immediate. You are going to pay the lawyer up front setting up this trust. I mentioned that, anywhere from $2,000 to $10,000, right? Could be a large range there. And it's probably going to be a little bit higher than the will. It may not always be, but it can be. Trust is a living, working document, and it may require updating. If you set up this trust when you're 60 and you live to 95, a lot of things have changed, and you can't just write this, throw it in the corner, and forget about it. Again, we need to update this and look at this document throughout years as the family grows. Maybe there's more marriages, more children, the family's expanding. You may want to include or exclude some of those people, but we need to update it. And again, if it is not funded, it's just an expensive stack of papers, and it's still part of your estate. And you do want to talk with your county assessor for homestead designations. So again, some of the pros and cons. Again, time often less than a will. If the revocable living trust is set up properly, once someone passes on, a very easy process, right? It can be less than 1% of the estate value. It's a private process, not open to the public. And again, it is possible for a trustee to administer and close the trust without major assistance from an attorney once that person has passed on. The next one here is the irrevocable living trust, non-changeable. So again, once you set this up, it's a lot more challenging to change how you set them up. These used to be quite popular in the last, I'll just say 10, 15 years, a little less common. The revocable living trusts have taken over for a variety of reasons. So again, the irrevocable living trust may reduce estate costs because assets are treated as a gift. You don't get the step up in basis, and these are not part of your estate. This is a whole separate entity. Grantor is not the trustee or the beneficiary in a true irrevocable trust. So once you set this up, they're a little tougher to change. So again, with medical assistance, if your irrevocable trust was established prior to July 1 of 2005, so again, we're talking about 20 years ago, mom is the grantor, she places the land into an irrevocable trust. The daughter is a trustee, mom can get the land rent, but not change any of the provisions of this irrevocable trust. In this case, land rent is a countable asset for medical assistance. So that is going to be when you go to a nursing home and if you pay the bill or the county pays the bill, right? That's medical assistance. So in this case, land rent is an asset that they can go after. So the income, the $100, $200 per acre per year, they can collect that, but they cannot go over the land as a whole. The land is protected. But the date is important. This is prior to July 1 of 2005. If it's been made after July of 2005, so if it's been made in the last, 19 years, this is the reality. Same scenario. Mom is the grantor, places land into the irrevocable trust. Daughter is the trustee of this irrevocable trust. Mom gets land rent, but she cannot change provisions of this trust. If medical assistance is an issue, right? If they need to, the state wants to go after your assets to pay your bills, assets considered countable assets for spend down requirements for applying for medical assistance. So to clarify, all the land rent are fair game for the state to go after for your nursing home bill if your irrevocable trust was set up after July 1 of 2005. So 20 years ago, if you threw your farmland in an irrevocable trust, it was protected from the nursing home. And that was kind of the golden ticket. They were very popular. After 2005, July 1 of 2005, that rule has gone away. And that's been leading to the revocable trust kind of taking over because you didn't get this land protection from the nursing home. And the irrevocable trusts have become a little less common. They're still used, they still have benefits, but they're not used as much because of that main issue. Charitable remainder trust. So CRT, it is an irrevocable trust. You can transfer assets to a charity, yet remain an income stream during you and your spouse's lifetime. So if you have, maybe there's a church that you've gone to your whole life and you want to give them some money when you pass on, this can be a very good tool. I think it's an underutilized tool if you're very charitable interested. And just to reiterate, your broke daughter is not a charity. This has to be a legitimate 501c3, 501c3, whatever, or 501c4. There's a few different charities, but it can't just be your poor children or your granddaughter who wants a college fund. That is not what this is meant for. This is a legitimate charity, again, a church the University of Minnesota, some other a lot of nonprofits can be charities. It can reduce your estate size, so there's a possible tax reduction. Can be a deductible for income tax purposes in the year of the gift. Can reduce self-employment tax. Very good tool if you want to give, you know, a sum of money to a church or a university or another charity. Okay, and again, I'll see if there's a question on this. Okay, so again, there are a good tool to use is those charitable remainder trusts. Again, FSA. FSA does not require a copy of your revocable living trust document unless the trust receives a payment or there's a recon of the farm. But just to keep this in mind, right, work with FSA, keep them in the know if you are looking at setting up a trust. So if you are thinking about a trust and you're like, you know what, I think this is what we want to do, just keep your local county FSA office in the know. They want to work with you. They don't want to fight down or hunt down paperwork after the fact. Just keep them in the know. FSA will require a copy of all irrevocable trust documents. They are a separate entity and will need a separate tax ID number. So irrevocable trust, it is mandatory up front. The revocable living trust, they will need one. They won't need it unless the trust receives payment or there's a recon on the farm. But just keeping them in the know. In wrapping up here today, be a good consumer of legal and financial advice. I talked a lot about wills and trusts. I was relatively like a 30,000-foot overview level. We did not dive into the weeds. I am not an attorney. I want to keep that in mind. Be careful legal planning with your attorney. And just being careful can help prevent farm transfer, estate planning mistakes, errors, and issues down the road. This is not legal, financial, or tax advice. I just want to highlight, we introduced some of these ideas and topics of wills and trusts, charitable remainder trusts that can be very beneficial to you and your farm and family. Talk with your lawyer and accountant to do the final steps and for some of the very specific questions that you may have. And with that, that wraps up our section here for today.